जवाहरलाल नेहरू यूनिवर्सिटी, BHU and TNU। उसके बाद 2005 के बाद से लेके बहुत सारी न्यू सेंट्रल यूनिवर्सिटीज वर क्रिएटेड एंड टुडे वी हैव अराउंड 20-25। Every state rather have at some of the state universities like Allahabad University from state to central university status have been given. Lucknow University is a state university, but then they created B.R. Ambedkar University, which is the central university. Then now Tripura Central University. And my visit was there only previously when I came to Tripura 3 times. It was Central University of Tripura. So this time, first time visiting this NLU Tripura. So somehow now every state actually have one of the central university, but Jamia is going to finally the central university, because that time only used to be 5 central universities. Hamdard is the one which came just 15 years back, but not as a central university. They want a status which is not with that too of a state university. Okay, yeah. So can we move the slides quickly? Yeah. So quickly we will see, because I will not much read these slides. So you can see the teaching of law in today's context. It is exciting but simultaneously challenging also. So for teaching as a skill, for some it may be intuitive, but for some it can be acquired by training. And it is one of the skills which can be learned, unlearned, and it can be relearned therefore. So there are different approaches to teach the law discipline, which are definitely need to be studied, analyzed, and explored by the law teachers, younger law teachers, future law teachers. However, this seems very complex, but it is a very enjoyable process, and the system that applies best practices and methods, instruments, and techniques. It requires some affirmative action and willingness to learn on the part of the teachers and scholars. क्या मेरे को ही मिल सकता है तो जरा इसका रिमोट कंट्रोल नहीं मिल सकता है? अच्छा ऐसा रिमोट नहीं, ऐसा कोई रिमोट नहीं है। अभी आपका ऑडिटोरियम भी और अच्छा हो। Okay, so for that there is a need for in-depth study of multi-dimensional method of teaching techniques. Whereby you can train yourself and which requires much of the things such as updating of the content. You had a workshop on updating content, syllabi updation?
Yes.
You had one lecture on syllabi updation. Yeah. So there are different aspects, and when we see in different universities, so even the syllabuses are different in different universities, which need to be updated. And you are sitting in an NLU. NLU is still a privilege that you are there. And it's only purely a law university. Because there is a difficult procedural dilemma in the university. If you want to update something, if it is a central university, it will take a long process. Your department can do it at one level, board of studies will take it. Then it will go to the academic council, then it will go to the executive council. Sometimes you get frustrated that if I am a teacher, and these are the students, and these things are required to be known to them today. Why that procedural dilemmas take so much of time, and it cannot be part of the syllabus, official syllabus. You can tell them otherwise, but it will not be covered in their examination unless it is approved by all the boards or the bodies of the university. So if it is a school like a law school or engineering college separately, then it's better because you focus on yourself, you get it passed quickly and use it. But if it is a bigger central university, their priorities. Biggest is always the engineering college, social science department, which itself have 8-9 departments, each one of them is bigger than a faculty of law type of faculty. So those are the issues which technicalities, I will say, which sometimes keeps you lag behind. And then third category, if you see, there are lots of private mushroom law. The law colleges which are in small areas, sometimes on paper law colleges, sometimes law colleges of very poor quality. The teachers are not getting proper salary. So why will they do all that exercise? Why will they do update the students? Sometimes they are not very well trained. And just because of not paying the equal or at par salary which should come to a teacher, they engage the teachers who are not fully qualified as well. Just because they for example, there was a teacher paying 30,000 rupees, a law teacher, and they will compromise on that even if the teacher is not qualified for net examination. So there are many dilemmas, and then they have poor infrastructure, there are no facilities, but ultimately the student pass out will be a lawyer standing in the same line. So you feel how much challenges they will have. You have everything, your courses just to apply all those things. Probably, I'm very sure, if anything is required in my future slide, you will see you will be requiring some ICT from the department, you will be requiring some type of equipment which will be required for your teaching methodology. Probably they will provide you. If you need a smart class, I think every law school will have a classroom whereby you can use ICT. But what do you imagine? In between there are people like central government universities. If you go to Delhi University, you will find many of the chairs which are broken, board is latka hua and all. But still they produce Supreme Court judges. Right? So the thing is, it depends upon person. But in that case, you will not say it all came from the university. It came because of being in Delhi and because of being other privileges.
But great teachers is there.
Yeah.
Great teachers like you as well.
Great teachers are there. Okay, but don't say me, but I've not been from Delhi University, but
actually, like in Mumbai University के अंदर में एक institute है, Jamia Bajaj, management institute.
नाम सुना है.
So that is called the CEO's Factory of India. So around 60-70% of the CEOs are Dalmia.
Yeah.
So, but if you go to that building, it will be a small room, wooden chairs with all just a neck color.
Yeah, so the typical and traditional method which was oral presentation by teacher जो अपना याद करके आ जाता था, and it was just an exercise based on mutual trust and understanding between the student and teacher. So lecture method, as you see, it was one of the oldest method. Still we give lecture. Lecture is not complete. The things are not complete. Ultimately, there should be a relation between the teacher and the student, and it is a lecture. It is, in fact, what you convey comes to the student. But what you convey, today they want to be authenticated by certain sources, isn't it? Immediately it should be present. You cannot just read them. So lecture was basically derived from the French word lecture, meaning reading, and it is an oral presentation intended to present information or teaches people about a particular subject. Next please. Yeah. So you can see that teacher, again, teachers used to be different, again only being a lecturer. That is why the first, now the terminology of the teachers has also changed. You are called assistant professors. We were called lecturers.
Yes.
We were called lecturers, and then we were readers, and then we were professors. So now so when you say lecturer, again being lecturer not only requires knowledge, this knowledge should be conveyed as well, which means जब आप lecture देते हो, you should be very clear, you should be loud enough that everybody listen to you, and your language should be the one which can be understood by majority of the people, which can be understood or which should be clear also. There is no point giving your lecture in a very highly accented manner, which is not generally people used to and they will not understand. Similarly, if you say something and it remains in your mouth, it will not be a good lecture. So even for a lecture, there should be some qualities in the teacher. But the most important quality was, it used to be one-sided, ex parte or student they sincerely आपको सुनते थे. There were no questions, there were no queries generally, and they were actually not supposed to. If I am saying you have to listen, you have to note down, notes लेते थे पहले बच्चे, अब तो कोई भी notes नहीं लिखता है, अब तो वह वो लिख रहे हैं, ये अच्छी बात है, पर अब जनरली कोई नहीं लिखता है. लिख लोगे तो दो तरह होते थे. एक तरह होता था, हिंदी भी सबको आता है ना समझ। One was some teacher used to just dictate itself. So there was a difference between dictate, whatever is your lecture you have prepared, you are maybe paucity of words or maybe you are not able to speak that fast and quickly. So and some of the students also, ma'am, what you said, please repeat. So in that case, many of the teachers were giving notes. So giving notes means to dictate each and every line was different than to I am speaking, I am saying something, but nothing like that is there. You can catch some words or you can catch some phrases and which you can put down. And out of that you can later on just recall, today ma'am taught this or sir taught this. Okay, but one method of some of the teachers have, and traditional teacher actually have. उनके जो कुछ पेजेस जो लेके आते थे वो येलो हो जाते थे, उसी को पढ़ाते रहते थे। आज तो अगर आप सेम ही लेक्चर एक हफ्ते के बाद किसी दूसरी जगह लेंगे, यू विल अगेन अपडेट इट, यू विल अगेन मेक इट, यू विल नॉट डू the previous days, like in the meantime some new cases in law, every day it is updated. So some new, even if it is a lecture method, something new will come which should be added in your lecture notes, isn't it? So even lecture method has been changed into it. And then secondly, even in lecture method, you should be receptive of taking queries, and you should also be ready to take a query which you may not be able to answer at that point of time. I'm not saying about you, I'm saying about myself, because I may not be that, technologically updated that whatever comes immediately. But I think all of you are quite equivalent to the student as well, isn't it? Whatever a student reads quickly, you also read quickly. So these students have become very smart. They will not listen you monotonously. So in lecture itself has become different today and very challenging. First of all, you can't impose whatever. In between, you will say, no ma'am, this has been, overruled yesterday. And you are not aware. I must say actually, I'm sorry, I have not seen that. Maybe it is. Till yesterday, it was like that. And then secondly, while teaching in the class, that will come in the later slides as well, you teach your student to grow. You don't teach them just to be in law, we have judgments. Don't you see judges themselves, whatever have been said by 3 judges earlier, or those dissenting judges' opinion, another that has become the overruling opinion in another judgment. So while we teach in the classroom, even by the lecture method, and you give them some case, at least I feel like that, and you also should feel, that whatever has been said by a bench of judges in a particular case or a particular single judge will not impose on them. These are the facts. This is what was said in this case, but not, maybe you have the dare or courage to say differently, interpret it. That should be the aura of the student of today, and this is what they want. They don't want, and that should not be the case. We should say, nahi, aap अगर मैं hypothetical problem भी देती हूँ and which immediately after dictating you make out, okay, this is based on Nanavati case or this is based on this case, you will give the judgment whatever was. No, you read the fact, you give your own, you can just change the course of the whole thing if you make the case that even if it is right of private defense, it was or it was not, or any benefit आप दे सकते. So your interpretation can be guided by your reading or teaching. What is the difference between a very, very senior and very famous lawyers and the common lawyers? The senior ones, they dare to interpret it more widely. Out of the same language, we can't change the language of the parent. It can be in fact changed by their greater interpretation later on that these words are saying this much or the volume is coming much out of it. It was not appropriately interpreted. So these students, this Gen Z or Gen X or Y, they are actually taking the things in their own stride. So go ahead please. Yeah. Here you can see this teacher's role is to coach and facilitate the students' learning and overall comprehension and material. Come to the next one. Yeah. So this another matter. How many of you have heard this Socratic method of teaching? Yeah. So generally, basically Socratic, who was a Socrates? He was a philosopher? Yeah. So actually it was basically question and answer and argumentative method. So Socratic method which is also now known as Socratic debate. It is a form of, cooperative, argumentative dialogue between the teacher and the student. And basically it is based on the process of asking and answering the questions, which stimulate critical thinking and to draw out the ideas and underlying presumptions. In the simplest form, the Socratic method could be characterized as a method of teaching by question and answer. Generally, Socratic method can be more successful when we have a class which whereby the student generally participate, or we can prepare the class for getting ready for some questions and answers on some particular topic. So the preparation for this type of class is done in advance. You make your student to to get prepared on one particular topic, and then another day there is a dialogue and class discussion on that subject. So it is a little ahead of the lecture method. Please go to the next slide. Yeah, so as we know that Socrates was a philosopher and thinker, and he is generally said to be the father of the Western philosophy. So the method which is called a Socratic method, it's basically developed the crucial legal analytical skills and accustom the student to the lawyer's adversary style of exchange. So this becomes a very important method of classroom, especially to the law student, because law students ultimately learn how to go for good arguments. So legal teaching requires this type of method also. Not necessary for all the classes. For example, if you are a teacher, for one class or two class, you can use Socratic method of teaching. It's not necessary for each and or maybe for one subject you can develop this method, and that we will do more argumentative. So here they make the student make the student to learn or think like a lawyer, and finally it helps the student to hone their verbal skills. Because of their argument, their some type of, if they have some hesitation, that also goes. Even asking the questions is a very important art. Not everybody can ask the question. Have you ever wondered? Many times we feel, "Jo question puch raha bewakoof hai," or the person has not heard carefully. Why you are asking? And many times actually we hesitate in asking the question. If some expert comes, who can ask the question? The one who is listening me. The one who is out of the class or out of the mind at the time cannot dare to ask the question. You can question when you are understanding at least partially and more than partially, and maybe what I am saying, you are thinking something further beyond to it, then only you can ask the question. Asking question is a very intelligent work. It is a very important task. Not everybody can ask the question. One can ask the question when you heard the previous thing carefully. So somehow Socratic method makes the student to participate, and there are many other innovative pedagogies to teach law are becoming popular, which are coming, but Socratic method actually persists. Especially it's very good for the legal education. Please go to the next one. Yeah, so case law method, which as I said that it's not, I will not say new method, but rather it is diminished in the today's time. In Delhi University actually, and even in my university, Legal Muslim University, where from I have passed, this was the method that we were from at the beginning of the session, we were given a booklet. For example, criminal law teacher will give this, constitutional law teacher will give this for each semester, and that booklet was containing some landmark judgments on the subject. Apart from, we were asked to explore the AIRs and Supreme Court. That time there were hard copies of the books only. Now we have a different era. But to go sit in the library, see that particular detailed case. But this case laws, one booklet which was the case law, and then you was being asked to read one particular case, and then they will discuss many legal points on that case. Like for example, one judgment which is on murder. It was some famous judgment. But while the teacher was teaching the case, what many sections were being covered? Both the sections of culpable homicide and murder difference. Then it was about the joint liability, common intention, common object, lots of concept, conspiracy, many things which were, because whenever some crime like that happens, lots of planning takes place, lots of mind meeting takes place, lots of some conspiracy takes place, some type of motive is involved. So many, it was, taking one case and different aspect of your subject used to be covered out of it. And context was also there. Otherwise, while we teach today, in fact, do you have trimester system also? Or
No, sir.
semester only?
Twice. Two semesters only.
Semester system.
Semester,
Two semester.
not trimester.
No.
So, जी मैंने देखा trimester system. We also started in Jamia Islamia initially when we started 5 years ago. So I'm taking when 3-year course was there. Till 15 year it was 3-year course. 2002 we started this. So just on the line of, because NLSUI was the pioneer, so taking the clue from there. अब उसमें वो पढ़ते कैसे थे? उनके पहले वाले सेमेस्टर जो फर्स्ट ट्राइमेस्टर था, उसमें उनको अगर आपने 34 और 49 पढ़ा दिया, कॉमन इंटेंशन, कॉमन ऑब्जेक्ट और कुछ और थोड़ा पढ़ा दिया, फिर नेक्स्ट सेमेस्टर जब आप गए कोई सब्सटेंसिव ऑफेंस के ऊपर, फिर जब उन्हें उसका केस हुआ, दे फॉरगॉटन द प्रीवियस थिंग. So no contextual. So in fact, even if it is annual exam, so case law method was having that beauty. That in one case, you are understanding multiple substantive offences, multiple, the things which revolves around the happening of a crime. So everything was taken in that context. So this was a very good method, and even today you can see that whether it is corporate law, property law, intellectual property law, if a case is there and case you understand properly, so many of the things which revolve in the subject will be clear. Many of the conceptual clarity will come. You will not read in the isolation that I have done this case on this particular topic, so it will be here, but that case will be very contextual. That was the beauty of studying by the case law. So decision of the court was not simply a judgment for the, So here case law method, please keep quiet. Case law method was also teaching them not only to see that this is a plaintiff or this is a defendant or this is the accused or this is a victim, that was also there. But simultaneously to understand both the arguments. Maybe you are not happy with the other argument which has become a winning argument. That was again a daring thing. That means you are going much deeper into it. You are understanding that case law much. So by reading the case, you was understanding clearly what are the different arguments from both the sides, which one will you agree, or even if you don't agree, then give your own argument. So case law method was one of the very good method, and it is actually, I still support it, that you make, because it becomes a cooperative learning also. The students' expectation is also there.
Madam, this is a very good initiative, particularly for legal education, and it seems that students are provided the material before. That was it. That is
Material with regard to text also.
yes. That is what you said, madam. That, particularly for a course, the landmark judgments, and then they are combined together and capsule they are provided.
You give it here?
We are also planning to start.
So there are two things. Nowadays, what is upcoming is notice that they give the the theory part as well. But I don't think that should be given. Case law is a different thing. Case law is compiled only few landmark cases. The whole theory will revolve around it. The whole section of everything will revolve around. But today many of the teachers give the notes type of thing, which I think there is no need. Today they can Google and find everything. More than that, here it was, you will discuss the ratio of the case, you will discuss the arbiter of the case, you will discuss the many concepts which are around the case. So case, this type of thing just can be.
How do we start preparing this? As an individual teacher, particularly for my course. So how do I start?
Which subject will be?
Contract law.
Contract law. So first of all, contract law का case material या कुछ cases हैं, even if those are English cases, but they are very relevant cases even today. Even they are privy council judgment. Though I am not a contract law teacher, but contract is a subject which everybody remembers. If you talk of some more BB, some more type cases, and many which never become redundant, which always remains relevant. So those cases, and then many things revolve around it. And then you can have in today's context contradiction of that as well. For example, if I say
just now I wanted to say this, that law in text, law in context and law in action.
Right, yes, it will come. But I want to just here tell you, for example, in Mori Bibi we say say minors contract is void ab initio. But today, many of the contract minors enters into impliedly, they order much of the shopping of the house, much of the shopping for themselves. Do they ask what is the age of the person who just ordered? But it is an implied contract which you enter into with the source from where you are getting some goods, isn't it? So all these things are required. In fact, it's high time, just like we have replaced criminal laws. Not much has been done, but still. So it is a time which we need to replace, and we are saying we are replacing the colonial laws. This is also colonial law, 1872. If that was 1860, it is 1872. Property law is also of that time. So you have come with the labor codes. So the things are happening. So even these things, and these things, especially technology, so fast. In fact, we are not even, today what we are bringing, we are not up to date. If you look at the Consumer Protection Act, which we replaced rather in 19, but it is not actually up to the mark keeping it. They are not talking as such of the online shopping. They are not talking about the consequence of that. Even criminal law we have got today, many of the things which we are talking requires changes like marital rape. Have they incorporated? Transgenders, definition में वर्ड डाल दिया, कहीं crimes में transgender का आया है, करने वाले में भी नहीं और victim में भी नहीं, nowhere. The things which they have incorporated, such as organized crime, so confusing. Anybody criminal law teacher? Yeah, teaching criminal law. No.
I have taught, but then from
This-
my area.
From long back.
No, just
You have taught BNS,
no. IPC. I
IPC, no BNS. Nothing has changed much. Which was required to be changed has not been done. Okay, so unfortunately, whatever is changed, which change I will say or addition I will say is not so. Okay, please go ahead. We have don't have that time. Yeah, please. इसको आप आगे flip कर सकते हैं. हाँ. So one is case law method and one is case study method as well. So case study method is basically, since we want our student to be in the field as well. We want to be just like you use the word actionist type of teaching. So they should know whatever they are studying, how it is beneficial to the society, how it is related to the society, what they are studying. So they should understand the society as well. Somehow what we say practical training, what we say pro bono clubs, what we say, legal aid cleaning. We want our student to go to the field. We want our student to talk to the laborers, to talk to the domestic, workers, to talk to the people in the area nearby. We adopt some villages or whatever, and we see that they understand what are their problem, and somehow simultaneously feel that what law they are studying, how it can be applied to them, how it can be benefit, or which law will be applicable to them, or which law will be, or even if they don't understand, they can at least make a discussion with their class teacher that how, if I met these people, which are the relevant laws for these people, how this will be taken ahead. In fact, while they are the student, many times they don't know the procedural. Yes, please.
I was just wondering, like, when you said case study, so, like, the traditional format that you just spoke about, like taking the students to different areas, but most of us have seen our law school that even if you are employing this traditional method, the result is not that very good. So
Which lecture method?
No, I'm talking about the case study method, like
Case
taking to court,
Huh.
or taking to the juvenile justice board, taking to the court.
Huh.
Many of the times, these are not producing very good outcomes. Like we also teach in the law.
See, there are 2-3 things. You are right. Even I was coming to the Licunas part. Like for example, when the student go to the area, but that's a part of actually legal aid cleaning itself. That they should be knowing the practical part of it, and that they should understand it in their own vicinity. But one thing which left is when they go to these people, even they don't know how to solve their problem. They can only understand theoretically, okay, this can come under the labor law, but what is the practical part? Secondly, to whom they go, they become very, they start expecting from you, as if you will solve their problem, you will take it to the court, which you can't do actually immediately. You can tell them the way out, you can tell them that if they cannot understand where to go, which authority to go, they can be actually directed to that authority. They can be given a clue about the recourse of action. For example, they can be told there are every court have a facility of providing legal aid. Legal aid is present. We have Legal Services Authority Act, which give help to the poor people with regard to acquiring a lawyer, with regard to providing them some money for their filing and all, facilitation rather I would say. So at least some way out can be told. Government is trying to do. Have you heard about the Nyaya Bandhu scheme?
Yes.
Yeah, so even in Nyaya Bandhu scheme, they want some of the alumni who can be part of that grant will be given to a university, Nyaya Bandhu. And actually this is the outcome of when our student in the name of legal aid clinic used to go to the field and take the thing. So this came that they have some expectation of solving their problem as well. But solution was not in their hand. They are the student, they can go to. So those alumni who have already passed out and they have to, that is why there is another aspect which nowadays is gaining momentum in the universities is alumni connect. Isn't it? They should be alumni, whether it is in the form of they can tomorrow put the internship of their younger students, or it is in the form of their legal aid thing taking forward in the form of Nyaya Bandhu scheme. So this actually basically this is more to make the student sensitive about the subject matter. Sensitive. Some of them they are studying law, but how many of them understand the dilemmas and the problems of the people? So they practice, but not also we make them learn that you should do some pro bono work as well, isn't it? We make them to feel that there should be some pro bono work, and this is how, if they see the real cases, if they see the real life situations of the society, then they are more sensitized towards their profession as well. Yeah, earning is one aspect, but simultaneously pro bono is another aspect.
I teach business cases to MBA technology management student in engineering college. I will support what you're saying. Sometimes teaching business cases as a case study method in the college is really working good, because when they sit for placements, so when the questions are asked by the recruiters, so they are able to appropriately correlate with the situation posed by the recruiters to the student. In such a scenario, how you would react to that.
Correct.
So teaching case studies is actually
Yes,
exposing them to.
It is actually, it is. Please go ahead. Yeah. क्या कोई एक AC on कर दीजिए ऐसे कुछ बात?
Yes, yes.
You can go further, please. Go to the next chapter. अभी आपका जो ये सिस्टम है ये ज़्यादा हाई क्लास नहीं है. Okay, so this is another method of teaching in the classroom, whereby which we generally do in our question papers as well. Isn't it? Sometimes we just give problems X, Y, Z, wala. So even in the classroom, can you please keep quiet? Yeah. So this problem method, basically what is the whole outcome will be, today it has the need is we should involve the student. We should not be one-sided teaching. So the more I will go ahead, I think I will go up to some 16, 17 methods, but then ultimately you will feel the ultimate purpose is that a student should be the equal partner in the class to sustain them in the class. Because today उनको आदत पड़ गया 2 मिनट के बाद वो उधर-उधर होने लगती हैं, और 1 घंटा तो क्लासरूम टाइम इसीलिए होता है कि you need a break, you can't sustain anybody for more than that time. So majorly to involve them in the class. Otherwise, even if your lecture is very, very brilliantly made, is of no use if the reception is not there properly. So more methods are being, taken care so that there is a reception. And what is the purpose of teaching? You should impart some knowledge to the people. So the purpose should be fulfilled. Better if they are involved, then the purpose is successful. Otherwise, it's not.
20 to 25 minutes attention span.
Yes, yes. Yeah, so this problem method is basically that you give some hypothetical factual situation to the student and center their analysis and then go for the discussion. And then the different ideas will come. Even how do you feel? You all must be making question papers, isn't it? And many times we believe in not only theory question, there should be some problem-based question. And when problem-based question, and especially hypothetical question, but in law, generally that hypothetical question want a support from some decided cases, isn't it? And that may be somehow based on that XYZ on a real case. But what do you want in the answer? Do you want it will answer what was held in that case, or do you leave the flexibility upon the student that he can make his new argument and can go the other way? I think the other, he can satisfy, but then there should be some reasoning of his own as well. Okay, not necessarily always you oppose the thing, but you have the, that you should have that capacity to go beyond, and that definitely, as I said, to say no is very difficult, to ask questions is a very difficult thing, to get the otherwise is a very difficult thing. So problem-based method of teaching is basically to inculcate this habit of the student, because then they will go depth of the subject and will understand and will have the courage that they can give a different argument. Yeah, please go next. Yeah. So there can be variations in the problem method. There can be complex, simple, or something in between, depending upon how advanced the students are and how experienced. For example, first year student, you will not be that tough. Second year you can be a little bit, and third year, fourth year, and third year, fourth year when they study, for example, criminal procedure code and evidence, or maybe third year they study evidence and fourth year criminal procedure code and second year criminal law. Then fourth year student will have a problem which may have all the components, and the thinking of the student should be to take care of the previously studied subject as well. Please go to the next slide. आगे भी जाइए और आगे चले जाइए ये प्रॉब्लम this seminar method. What is the seminar method of teaching? Yeah, generally to the final year student and to the LLM student. Yeah. So we believe in this one method which is called the seminar method of teaching. And this seminar method of teaching is generally talks about some structured group discussion. You float a topic, and not one topic. In fact, if it is a class of 30-40 people, you float 4-5 topics and then make the groups on each topic, and then they research into that topic, and after the research, the discussion starts. So this is another very involvement of the student. So these are in the form of some type of paper presentation, then the group will make their own preparation, then among themselves they will choose who will give the presentation, and all of them will be ready to answer the questions of that. So here, this type of teaching method requires much pre-preparation by the faculty. This all cannot be done suddenly, you come and suddenly you do. This all requires a very prior, setting and prior preparation. So this topic which is given, it can be a subject or a topic delivered in an article, report or working paper. It can be anything, it can be some subject matter, some topic from the book, or it can be some particular article published by somebody, or it can be some government report. Anything which can become, any contemporary subject matter can become the discussion matter of the seminar. But it should be definitely, we don't have time. Sometimes the time constraint, stops us from innovating. Go to the next. So, seminar method is again, it's just to be taken, and I think you people should try in 1 or 2 lectures of yours the seminar method. You can go next, please. Next. Yeah. So, research method is basically research methodology all of you might have studied. So this is again not much applicable to the undergraduate student, but to the postgraduate student, and here they will again take some topic and It refers to the methods, techniques and tools which can be employed by a researcher. Somehow, again, whatever is theory, but like we say in research consider doctrinal and non-doctrinal research. So in doctrinal part, you read all the literature, you read the subject, and then you test that subject matter with some societal problem for what it is meant, and for that you live go to the field, collect the data, analyze that data, and using the tools and techniques of the research, and then ultimately you reach to some conclusion. So again, this is a method which you can employ if you have LLM here.
Yes, ma'am.
So if to the LLM student, the component of teaching is like for example 75-25. What is the breakup of their evaluation?
50-50 is written exam, 50
हाँ, तो
is
आपके पास तो बहुत स्कोप है. अगर 50-50 है तो 50% टीचिंग, उस 50% जो आपका असाइनमेंट वाला पार्ट है उसमें they can be exposed to this particular. आगे भी चलेगा. Okay. Then this another method is critical thinking. This again is basically to engage the student. Critical legal studies. So this can be defined as a method of legal analysis that argues not only that law is indiscriminate, but that it is used to conceal and justify unacceptable hierarchies of the social power. So somehow critically making the student to think critically, not only to think things as it is, but to think many things critically. Like we, after independence, we got the constitution, and in the constitution we say Article 14 says equality before the law and equal protection of the law. But simultaneously, the makers were aware that what they are saying in 14 is not actually practically true. That is why Article 15, which says that the state can say no discrimination on the basis of caste, creed, color, sex or religion, and then the state wants they can make special laws for the women and children, because they were aware that the gender justice is not there, the equality is not there because of the higher patriarchal setup of the society. So such type of critical, even from the laws, the major topic which I was giving, the feminist method. So I will come on that, and that will be the most interesting thing. Because the way society has taken the thing, the vocabulary is also like that. The thing, so should we give the student the scope to critically analyze any particular law? Because we have the feudal system, we have the patriarchal system, so even in the land laws there are biases or the perspective of the student, today's perspective. They are this generation. So, and they have the right to criticize. That critical analysis will get them to grow. And if that is correct, it should be. So, everywhere there can be school for critical. अभी आप यहाँ बैठे हो, सब कुछ करो, बहुत अच्छा है, बहुत अच्छा है, बहुत अच्छा है. That's the habit of pleasing, and generally चलो हजारों लोगों से अच्छा है. But then if we have our own content, we can say, we can improve that. I mean, even criticism can be very positive as well. So critical thinking method makes the student that whatever the theory is, and that leads to the development actually. If everything, whatever has been written once, is perfect forever, then there is no scope for improvement. So scope for, even the constitution, we always say it's a growing document. It's not static. So it is like that. So we have this scope for critical. Things happen, even amendments are made, but even to amendment we can criticize that this could have been done this way. But then you should have a courage to say which way. Yes. Frame that language. Okay, go ahead. Yeah. So this helps in the construction of new theories relating to the subject. Okay, please go ahead. So delivering this method is not easy. The teacher must think beyond the boundaries and show how a law has evolved and draws a critical analysis rather than just describe its features. So this method enables the learner to think beyond the black letter rules and regulation of the law and allows them to deconstruct and analyze them in order to understand the way in which they have been constructed. Go ahead, please. Then comparative. Have you ever used in your classroom teaching comparative method? Anybody? Yes, please. And how and why this become very important? Today we are living in a world which has shrunk to be a globe or to be a village. And so much of comparison. Even our judges, while give the judgment, are not the precedent. There are very many American High Court, Supreme Court judgments, Australian Supreme. There's lots of borrowing, isn't it? There's lots of borrowing in our legal system. In fact, all our laws are from the Britishers, even afterwards laws. And otherwise also, we say the Constitution, fundamental rights from American Constitution, directive principles from Ireland, and this from this, this from that. So what was the purpose? To make it best. To make it best. So borrowing is not always stealing or cheating. Borrowing is to make the thing perfect, to make the thing good, to look at the other society, but not the blind borrowing. We should see what is our system, we should see what is our society, we should see our culture, our ethics, our things, and then if some type of comparing, but it's very necessary for the growth, we should see the other society. If we say we are a developing country, we want to be a developed country, isn't it we should look ahead? Yes.
I don't have the exact judgment reference, but somewhere I read few days back that one girl, she was given a sentence of 13 years imprisonment in UK because she has stabbed the person who was molested and attempted a rape. But same thing happens in India. I don't think that girl will get a 13 year imprisonment because of self-defense here attacked by.
Because she was.
No, not because he is a girl. In self-defense, he has stabbed the person.
That big punishment will not be given.
I don't think in India.
You mean, I just want to understand, is the gravity of the offense you're talking about?
No, I'm talking about in UK. That was the judgment. What would have happened in India? I'm not sure because I'm not from
No, that I got. But I mean to say that girl stabbed somebody and she was given a 13-year punishment. Is what I think. So you mean to say just merely for stabbing 13-year punishment?
No, in UK it is 13 years. In India, would it be 13 years also?
That is another question. I mean to say you are saying in UK the punishment is very big for simply stabbing. First this question should be decided.
No, it is not into the self-defense. So in my
okay.
opinion, it is different.
Why it cannot be given? If self-defense has many conditions as well. If the threat was very close to you, even you can kill somebody. If the threat is close to you, but self-defense cannot be, for example, somebody tells you that he want to rape you and coming there, and then you also move there and you will stab the person and kill him. So our self-defense in our Indian law is very justified, and there they say, though the amount of force cannot be measured in the golden scale, but there is a reasonable logic. Got it?
I wanted to understand from the perspective of comparative.
Yeah, so that is what I am telling you. So comparative methods are basically, they are very useful. And today they are very much useful. If we teach our students and we are saying...
Like advisory and inquisitorial, there are two sections because sorry saving, so in that context if we talk about it, particularly regarding the criminal justice, say for example, then we are having two models available. One is adversarial, one is inquisitorial.
And that's one thing, but his contention was that if the girl just merely she was expecting the person is going to harm her, she used or she stabbed somebody in a self-defense. So whether the punishment of 13 years is
not very it was an attack. Actually, it was an attack.
Yeah, it was an attack. So it can even be life imprisonment. So that can be justified, provided the situation and the circumstances of actual fact are in her favor. Right? Yeah. So comparative method is very important nowadays when you teach students, because when even you teach the judgment, as I already told you, that you are always referring to very many, none of the important judgment of the Supreme Court comes without any reference to some important judgment on the same point it made, Australian Court or the American Court. Similarly, teaching. When we teach Constitution, when we teach criminal law, understanding the other country's system becomes very important for our development. Whenever we make laws, we always take into consideration that how the other, but we cannot blindly borrow the things, we cannot blindly take their things. While taking, we should be justified, we should be contextual, and we should see whether it will suit to our, because we are otherwise culturally different from many countries, we are ethically different. So things should be in our stride, it should be, like as I gave the example of Constitution. while we make the constitution, we very boastly say that our constitution makers have done a deep research and they borrowed the fundamental right from American constitution, they borrowed directive principles from Irish constitution, fundamental duties from which was German? No, German is emergency. So every important thing have been borrowed from different one, and with that we also boast from lengthiest constitution of the world, which means a very detailed constitution. So somehow that is the result of the comparison. So making the student to study, you can, actually I always suggest while making the curriculum, we can incorporate some component of comparative analysis of the subject with certain countries with which we generally compare. So please go ahead. Yeah. So you can now understand, I think time is short. Go to the next one. Yeah. For any subject, for example, you think of any subject and you want to look at how this particular country is dealing with, maybe it's consumer protection or it can get people's law, it can be, because these things have evolved. For example, obscenity, adultery, you know the latest judgment. So they definitely have seen, even the judges always look at that. Yeah, so the real aim of the comparative law is to offer insight and perspective so that we are better equipped to reflect critically about ourselves and about our own legal culture as well. Yeah, please go to the next. You can read it later on because I have jotted on. Yeah. So feminist method, when we say, how many of you have ever thought of feminist method of thinking? You have? Okay. So any one of you are aware that the Supreme Court have come up with one glossary probably, which is giving some gender, the word which were used in our legal system, and they happen to be a little biased type of, and they have evolved a new vocabulary that we can in future use for that. Yeah, so it is a handbook on, you can just see in your phones or in your system, handbook on combating gender stereotypes. This is at the time of Justice D.Y. Chandrachud, he in 2023 he created this particular handbook, and first I would make you to understand this, and then you can go for that. So this feminist method of law teaching is an innovative and less explored way of starting a discourse on giving a feminist perspective to the law teaching. In other words, feminist ideas are challenging to the status quo because of it. But you see in everyday judicial system, apart from this handbook, it is otherwise also evolving. Like for example, some old cases, before Mathura case, in criminal law there was some very landmark. The perception was that a woman is of loose character, she cannot claim the remedy for the right because she is declared as she is a prostitute. But no. Even if she is a prostitute, if something happens without her consent, it will amount to rape. She will be equally rightful to get the remedy out of her. The person will be equally punished merely taking the plea because this woman was of easy virtue, she was available. So how can she be claiming that the offence committed against her? So this is actually the feminist approach. Similarly, many other things, like for example, women were it can be other way around, I'm telling you. Many women were, generally it was taken, women cannot be dacoits, women cannot be thieves generally, women cannot be into drug trafficking. But no, just merely saying she is a woman, so how can we make her guilty of this offense? These are the offenses committed by the man only. No, in that context also, society is evolving, things are changing. So when we say feminist approach, have you seen that handbook on which I have just told you? Yeah.
So madam, basically it is substantive equality and justice, right?
Yes. Towards which we are approaching. And when we say equality, and when we use it on gender itself, see, sex and gender are different. Sex are male and female. So when we say gender, so gender, today when we talk about gender equality, what do we mean? That means anybody can do anything. Women, if she gave birth to a child, later on she can go to the place of husband and look after. And the government is also supporting it. Then apart from, your maternity leave, there are paternity leave as well. And this is happening. So then it's not always girls are pink and boys are blue. It can be the other way. And that is happening, and the present generation is accepting it all. Earlier, not only people were so much into their own chores and their own roles, but simultaneously society was also cursing them. If some man sits at home and do the cooking.
Yes,
So,
that's not your duty. And
yeah, exactly. And it's very shameful. I will do it, but okay.
Yes, ma'am.
I will not do it like that. So if we say equality, it should be equality. Yes, ma'am.
We look into feminist completely from different contexts. We look into global south, international law, and feminism. So we look into what international law offers to the female.
Yeah.
Is it only portrayed as a victim or also include women in the decision-making process of the
They
international
are in the decision making. They are everywhere in the decision. Even if you look at United Nations, even if you look all the conventions, if you read the conventions carefully, sustainable development goal is
Yes.
isn't it? Yeah. So please read this one, please carefully read this one. Because this is very important. This is a new approach which you should all, however I will come some, मेरे पास time है, मेरे को काफी रहता है। अभी मैं सबसे important एक flip classes डालूंगी आपका, please. Okay, so this is because the definition of the term feminism, that is its foundation in the assertion that equal rights of women are necessary, assumes the existence of inequality and the need for societal change. So why the societal, have you seen some vocabulary in that glossary? That itself speaks. Harassed women, how she will be taken. Adulteress, how she will be, they have given new nomenclatures in that dictionary. So that's also an indicator that how the feminist approach should be involved in the whole law teaching. Because what they will study, they will later on use the same approach in their practical life. Okay. So while working on these questions, the feminist method suggests that we need to change our structure of inquiry to newer method of understanding men and women. This method is basically based on the premise that simply adding women's experience to the law school curriculum cannot transform our perspective of law unless it also transforms our legal method. Yeah. So this method challenges are deeply held, often sacred beliefs that which are rooted in the emotions and expressed in the primitive imagery. Then continuous discourse on efforts made in the legal profession towards improving the existing differences of gender-based discrimination, it can be highlighted in the lectures. For example, while we teach any subject, we can't ignore the precedent. We can't ignore the previously, decided cases. Yeah. But if some previously decided cases stand good in today's context with regard to some ratio, but with regard to vocabulary or with regard to the whole dealing of the case, it stands strong. So today we need to correct that. Today we need to go ahead in today's context. So the case method can be used as a part of feminist method to discuss the approaches used by the judges in deciding claims concerning new laws for the women in society. Please go to the next one. Yeah. So judgments which are detailing the accomplishment of women in their different responsibilities as judges, as lawyers, as academicians, and in-house counsel can further be elaborated upon to highlight the existence of gender-based difference in the society. Actually, one thing here I would like to just share. So even the classrooms has changed. Whether it is this type of classroom or whether it is a student classroom. When I was a student, there used to be only 3 girls in our class. In a classroom, big classroom of some 60, 80 people. And then the next year I noticed in our junior batch there was not even a single girl. Then after that, some more girls. And when I started teaching way back in 1991, there used to be 7, 8 girls in the class. I'm talking my classroom in 1985-86. And then I'm teaching my classroom while I was teaching in 1991. So 7, 8 girls. But then it all started changing. And today what is it?
Majority are
the girls sitting and yes, the boys sitting in the class. Even in the admission that day. So when that has become the case, अभी भी सर ने आके एक नंबर बढ़ा दिया वरना कम हुआ. So this pattern is automatically going on to evolve. This vocabulary is automatically going on to change. Yeah. Yeah. So additionally, interpretation of the statutes to determine the intention of the lawmakers from the feminist perspective shall be done in order to bring the change in the method of inquiry. And feminist judgment writing project can be allocated to the students. So here, what can be your role? Look at the second point. So you can, while you are giving them or some particular case which is being taught in the class, there can be some projects. They have internal assessment where they write some. They should be. This is another thing which I have noticed in the classroom. Where now we have, in our time, 100 number का paper हो जाता था. Now we have all this 75-25, and you are saying 50-50. So that 50 marks which they mug up and write in the exam, but the other 50 marks are very creative marks. This is for the project, which unfortunately they just download something and give it to you, which should not happen. But for that, teachers have to be really hard working. They have to look into one-to-one student and give them the project, and then even evaluating it. That's a task which lies upon the teacher. So it requires more and more sincerity on the part of the teacher and more involvement of the teacher. Merely just end of the semester, you just take the submission, बुला के ऐसे रेवड़ियाँ बांट देते हैं सारे teachers को, and you just give them some 15 out of 20 marks, something like that. But that should not be actually the case. You can give them some project, but immediately you have to evaluate that, and that will be a learning process. Okay. So even a case study method can be used as part of the feminism. We have done case study method. You can involve a case study that some women can be studied, and then you can see that to understand the real life experiences of women from their own perspective. And then lastly, I told you about that glossary. Go through, and that automatically will give you an idea in whatever class you are teaching that what type of vocabulary one should use when it comes to context of it. Many of the words which were earlier part of the legal vocabulary used in the court again and again, they have been taken as very, disturbing and derogatory today and to be replaced. Go next.
Available in some e-library.
वो आपके साथ मंगा सकते हैं. He's saying, can we have that handbook glossary? You can. Otherwise, it's you can download. Yeah. So I think clinical method मैं छोड़ने वाली हूँ because I think there is one.
Ma'am, I have one question, ma'am.
Yeah.
Whether Nargis Mirza case can be referred in?
Yes, it can be. Yes, it can be. It is a case, and thereby the result was actually better. But the initial proceeding was Nargis Mirza case. In fact, there are many more cases.
And whether Vishaka was a state of Rajasthan?
Even that. Yeah. That female being a school teacher, and then just because she was a female. There are many more cases which are in the series. Okay. So clinical collaborative method is basically cooperative and group team learning. Again here it requires a teacher to integrate different learning preferences of the course goals. And then accordingly the student, what we are switching and continuously going ahead is in every method which is the next, you see the involvement of the student, and which is a requirement of the time to keep them involved in the class. Because the students have, technology and their upskilling with regard to the, they are more upskilled than all of us, to me at least. So they are not involved in the class. They feel whatever teacher is saying, we can immediately Google and we'll find out. So but actually that's not correct thing. So their involvement, how to involve more and more the student in the class, not let it one-sided in particular, which is actually not. We started with that, lecture method, but that is good method, but not going on to retain today, not going on to survive today. We need to, incorporate the method which can involve the student more. And whenever we involve the student, actually it becomes facilitate a broad spectrum of cognitive, effective and interpersonal goals. And it also facilitates critical thinking, reasoning and problem. And then they become very enthusiastic in the class. If you collaborate with the student, they become very enthusiastic. Yeah, but there are certain dilemmas for that. Some student gets absent one day, you make it go, you give the task, you this the next day. So this requires continuous involvement of the teacher as well as the student. Yeah, please go next. You can go further next. Yeah. On architecture. If you find interesting, I will leave it here itself. Yeah, this is action teaching method. Somebody asked me at that point of time, action teaching. So this method is again, it is used to investigate and inquire about the issues which are affecting society. And somehow you can club it with case study method. Okay, yeah. And the student should be aware of the needs and the requirements and the issues of the society, and simultaneously being the student of law. Just like हम पढ़ रहे हैं, हमने बस पास कर लेना वाला अप्रोच ना होके, हम जो पढ़ रहे हैं वो किसी को कैसे हेल्प कर सकता है. So they should, and that will give them interest also in the subject also. That will give them purpose of study also if they are actually into action teaching method. So this quantitative research method is often used to inquire about the efficacy of the implementation of the statute, and then what measure and to what extent it measures its impact on society. So it is not only about that what they are studying, how that will be implemented, that statute. Many times our students study and they just remain हमने पढ़ लिया, पर जब practical का time आता है तो फिर उन्हें डर लगता है how it will happen, and they actually practically apply when they take some case on that. And here the concern is that from now onward they should feel either by taking a fees later on or being a pro bono, how their knowledge is going on to be helpful to the student. Please go ahead. So action method is basically their understanding of the society and their action and learning with regard to the society. It's a classroom to the field. आगे चले जाओ. Then ये जो words हैं outcome based learning method. This method promotes an outcome based model of learning that requires future driven curriculum focus to be developed, and जो हम curriculum अपना बनाते हैं वो हमारा पता होना चाहिए that what will be the outcome. Many times एक curriculum बन गया वो चलता जा रहा how much अभी तो थोड़ा अच्छा हो गया, पहले एक subject का syllabus जिसे कहते हैं वो बन गया और वो चल रहा है. But curriculum should be updated very frequently, very regularly, and we should know what. That is why today actually many formalities are compared outcome-based teaching, outcome-based learning, and then also the evaluation even of teachers by the student, peer evaluation. Lots of exercises are there. So when we teach them, we should see whether it is updated, what will be the outcome. Is it just because we are teaching it, or it has some relevance? Yeah. So outcome based is basically relevance based. Yeah. Go next. And students are very friendly about it. They will themselves feel, अरे इसका हम क्या करेंगे पढ़ के? ये तो अब खत्म हो गया. Yeah. So this method would require the law school to identify the knowledge and skills and professional attributes that the student should possess. This is basically about how the curriculum should be designed, and you should be, while you are teaching to the student, you should again and again tell them that your curriculum is outcome based and these are the outcomes of this course curriculum. Please go ahead. Next आप जा सकते हो. आजकल feedback का भी बहुत ज़माना है. तो एक होता है ये integrated reflective learning method. This method is actually again dialogue between thinking and doing. So the teacher who uses this method integrates theory and practice and reflect on practice what one does and what one knows. So again practical, and your learning should reflect that how your learning is getting the skill which you are acquiring is beneficial later on, whether that is why we do all this mooting and all. Why does student do mooting? Why does student give with advocacy? And nowadays another thing, client counseling is also cross-examination. So all this they are being given all this practical training. You can go next. I think, yeah. So another is blended learning. ये अभी जो ज़माना आया था जो online teaching or offline teaching. I don't know, the COVID came at a point of time when actually it was a high time to switch over to the technology in many ways. But COVID made it compulsory and COVID made it मजबूरी rather कि आपको ऐसे ही पढ़ाना है और ऐसे ही चलना है. तो उसके बाद से बहुत सारी चीजें अभी हम लोग कई बार अगर कोई छुट्टी पड़ गई और अगर एक्स्ट्रा क्लास लेना है, you can I am fixing despite every day's classroom going on and weekday you're taking a class, but if you want to cover some extra syllabus, some extra thing, some extra teaching, you can fix a class and one link and then you will. So blended learning have become the need of the time, be it because of some dilemmas and majburi, but or because of they are the they are the need of the time. Every time it has become so easy, you can just fix a meeting whether a person is sitting in United States, whether a person is sitting in UK or Australia. So there are no barriers. Even the courses like FDP, after physical, you can do many FDP.
Majority are in online mode.
Online, and then again the university boundaries been able to, you can do many courses, many certificate courses. जो आपने जिस यूनिवर्सिटी से भी लेना है, you can.
Offline is still better.
Online is still better. टीचर के लिए तो better. क्योंकि बस ऑनलाइन में एक ही था कि कौन अपना कैमरा बंद करके क्या कर रहा है, तो खाली अकेले बोल रहे हो या. So that's a very odd part. Please go next. तो अभी जो लास्ट है वो भी थोड़ा इससे मिलता हुआ या ये फ्लिप क्लास मेथड, ये जो है एक बहुत सबसे ज़्यादा अच्छा मेथड है जो इस वक्त आप लोग यूज कर सकते हो. This is an actually offshoot of the blended learning method. It also combines the use of both offline as well as the online technique of law teaching. This is known because of the fact that it reverses the traditional method of teaching, where students are introduced to new information in the classroom. Rather, in this method, a topic is taught through the videos, through the links, through some videos, through some. So, flip class method is an active student. So, most of the अभी जो last वाले 3-4 हैं उनमें आपने note करा होगा सब student active वाले methods हैं. पहले शुरू वाले teacher centric थे, बाद वाले collaborative student centric. Then there are more involvement of the student. So, similarly, this flip class method is an active student centered approach to teaching and follow an integrative teaching pedagogy. It allows the use of multiple tools such as online videos, presentations, learning, management system, taking notes and preparing questions about the part that they do not understand. Go next please. Yeah. So this flip method of teaching fosters an environment of group learning, problem solving, discussion and making an inference. And the procedure of this method involves identifying which portions of the course will be best suited for the transition to the flip. Not necessarily the whole course you can teach about that, but for certain portions you can, use. But in all of them, though students are actively involved, but the teacher job is also increased. They have to do something. They have to make prior preparation for, taking on that. So some preparation of videos, explaining the concept at the medium pace, and this allows the student to pause and rewind the concept for better clarity and thus give ownership to student over their learning. So further there can be some charts and diagrams with their, this can also be used, and these are again and again can be rewinded and yes please. Okay. So the student can be continuously, you can see, it involves the student for preparing notes, for preparing outline, and they can also be involved. In fact, as a teacher like me, a student can make a better video than what I will do. So their involvement can do that, and they will be very happily involved in that. Because this is the thing they like. They always like such type of work, and many of them are, some students are always active in the classroom things, whether assisting the teachers. So this type of things they further more impressive. I think with this I will finish, and otherwise a teacher there is no end.